lot of people's job title around the world. And it's such a nice word, harmonization. What does that mean? It's so musical, it's so nice. And you know, certain types of harmonization can be really nice. I mean, it thrills me that I can go anywhere in the world and stick my ATM card in any machine in the world. And this is an international standard that's set by the International Organization on Standardization. And this is an international harmonized standard. It's voluntary, it's a good idea, and it works. Here's another one, floppy disk. You can use most computers these days, except floppy disks of this size. And this is another international harmonized standard. And these kinds of technical standards for certain types of products, which are voluntary, which are made in international standard setting organizations, which have all sorts of different governance structures. Sometimes they work by consensus, and sometimes they work by votes. But for years and years and years, they've been working away, making all sorts of international standards on all sorts of different products and food types and just about anything you can think of. And then something changed. These organizations were working away, and two of the biggest ones was the International Organization on Standardization, which deals with a lot of technical and product standards, and the Codex Alimentarius in Rome, which deals with a lot of food standards. They've been working away, Codex in '62, I'm not sure ISO since when, for years. But all of a sudden, in recent years, what's going on in these organizations has been transformative. These organizations went from sort of, especially the Codex, went from being a sort of sleepy little backwaters organization that was organized under the auspices of the United Nations to set international standards, food safety standards on issues sort of like maximum residue levels for pesticide for foods. You know, how much pesticide is safe on your avocados and how much pesticide is safe on your lettuce. And these pesticide standards were for years very helpful to a lot of developing nations that didn't have the science to do all this analysis themselves. But in 1995, when the World Trade Organization was formed, this sort of, you know, helpful, voluntary, consensus-based, sleepy little organization turned into a hotbed of political intrigue. All of a sudden, everybody was there at the Codex, and everybody was there at the ISO, and people were going to Codex meetings all over the world. And we had a recent one in Chiba, Japan, that talked about genetically modified organisms. And it's because the World Trade Organization has said that international standards are where it's at. International standards are the only standards that pass WTO muster, that are WTO legal standards. And so our speakers here tonight are going to tell us a little bit about how all this works and what the implications are for this type of international standard setting for our dinner plates, for our minivans, for all sorts of standards that go far beyond the sort of simple technical standards, and they get into areas of public health, the environment, worker safety, food safety, and how that's all impacted by the WTO and how it impacts your lives in democratic governance making in the United States. Our first speaker is Lori Wallach, who's the director of Global Trade Watch. Lori is a trade attorney, and she's been working on these issues for 10 years, and she's going to lay out the story of what's going on here. Lori?
What I thought I would do is I would go sort of at the broadest view and set the context, which my colleagues will then fill in some of the details about, and that is to talk about where this concept of harmonization and the broader phenomenon of globalization is coming from. Because if you listen to the public relations of the beneficiaries of the current model of globalization, one would assume the concept, to say nothing of the rules, to say nothing of the entire WTO agreement, came down from Mount Sinai with Moses directly from God. Alternatively, you might have concluded it was an inevitability, a matter of science, or who knows. In fact, what we have is the World Trade Organization agreement, the Uruguay round. It set up a new institution and 21 substantive agreements of substantive rules enforced by that new institution, the WTO. And it is just one version of how one could set up global rules. About the economy, but these rules also expand into many areas of law and policy that previously were decided domestically. And this agreement, as well as its regional cousin, the North American Free Trade Agreement, are often called free trade. And probably someplace the British philosophers who came up with the concept of free trade, guys like Adam Smith and David Ricardo, are spinning in their graves that this 900 pages of rules is being called free trade, which would take one page. No rules. This is managed trade, if you want to compare it to the slogans free trade, managed trade. And it's just one version of managed trade. And if you look where it comes from, it really can be accurately described as corporate managed trade. When the Uruguay round of GATT and the NAFTA were negotiated, the U.S. law about trade negotiating that's linked to the so-called fast-track mechanism empowered 500 corporate representatives to be official, credentialed, security-cleared advisors to our government negotiators. At that time, there were 16 labor representatives and 0 representatives from health groups, 0 from environmental groups, 0 from consumer groups, 0 from family farm groups, 0 from civil rights groups, human rights groups, indigenous peoples groups. Except for those labor folks, it was all corporate, which does not thus make it a totally shocking outcome that these rules are often described as the trade über alles rules. Trade always trumps, and democracy ends up in the trash bin. You've all heard the old slogan, whoever makes the rules, rules. And this is a very good example of that. Now, the reason why I haul this cumbersome book around is just to reiterate to folks that there's nothing inevitable about this version of it. It's just one way you could set globalization, this one set of rules. And it has outcomes that can be tracked, which I'm going to describe a little bit of. And if we don't like the results, we can change, transform, replace the rules. And for so many people, this has been mystified. Free trade, the concept. Who can be against it? Well, give me a break. It's just one set of rules. There's nothing mystical about it. It's just some paper. And if it's not suiting us, we need to change it. And so I haul it around so everyone can actually realize and get their hands on it. Everyone's willing, would like to is welcome to come up here and throw the WTO around. That it's just a thing that we can change. Now, the theory of free trade, of course, is very different than what's in there. And Mary asked me to try and explain a little bit of what literally is in there. And the way I'm going to describe this, let me step back broadly one more time, is to say that we have this whole phenomenon that gets called globalization. And it's really, it is a set of results that are very complicated and very broad that are being implemented under really an alphabet soup of different mechanisms of globalization. It doesn't happen randomly. And the alphabet soup certainly includes the WTO, the NAFTA, the North American Free Trade Agreement, but also the IMF, the World Bank, the CBI, the AGOA, the FTAA, the APEC, the OECD, which gave us almost the MAI, which almost replaced the MIA, FYI. So these particular acronyms, I'm not going to translate them all out, are similar in that they take an approach where in many instances they take away, they constrain the rights of governments to promote the public interest, namely by constraining corporate activity. And in a way to think about it is many of the basic principles of the social contract that would constrain the excesses of unregulated capital to maximize its profit, those government actions are the ones that are deregulated. But there's a lot of new restriction put in too. It's not all just liberalization, which is why it's so clearly a managed trade system. For instance, there are many places in which new protections are put in place for investors, or new protections are put in place to try and protect a corporate interest. And a classic example is that one of the agreements enforced by the WTO is a trade-related intellectual property agreement called TRIPS in GATT's. And the TRIPS agreement sets up what may be the world's biggest new trade restraint. It is a 20-year monopoly right to market given to any corporation who holds a patent in one country for all 136 WTO countries for 20 years. This is a clear restraint of trade and competition. One corporation files a patent on one thing, and these patents can be filed on seeds, life forms, pharmaceuticals, and then they have the worldwide right to do anything with that information or technology for 20 years. Now, in the US, we've had systems similar to this for patenting. In India, it was a crime. It was not allowed to patent a seed. In many countries, it's a crime to try and patent a life form. In Canada, up until NAFTA, there wasn't mandatory patenting with mandatory marketing rights for pharmaceuticals to keep the cost of medicine down. These are all value choices that have been imposed one size fits all, and these are new constraints on deregulation in favor of corporations. Now, the way the WTO works totally, and this gets to the harmonization issue, is that it sets up constraints in which all of its member countries must operate. And it sets up rules covering a whole new set of issues that were never covered under, for instance, the old GATT, the old trade rules. So new issues like service sector, banking regulation, insurance, transportation, intellectual property, like I mentioned, but also government procurement, how your tax dollars get spent, and a whole set of standards that have to do with pesticide standards on food, meat inspection, technical standards, worker safety standards. All of those issues now have agreements which set constraints on what governments can do. And the WTO sets constraints on the goals that a government can seek in these areas, and also the means of implementing even the goals that are WTO permitted. Now, the reason why I laid out that way, and it's pretty dramatic transformation, is that in the old days, the GATT, the global trade rules, really focused on traditional trade matters, tariffs, quotas, and it basically implemented some fairly objective principles, like national treatment. You don't treat a product differently according to what country it's been produced in. But with the WTO and the other way around, the global trade system was transformed into expanding into this pervasive set of subjective value decisions. And for people who wonder what happened, all of a sudden over the last 10 years there's this fighting back on globalization. If you ask me, it was the shift from the objective principles that had to do with commerce into this enormous set of subjective values about how much safety a country can demand for its food, or what right poor consumers have to have access to pharmaceuticals in South Africa. Footnote, that whole huge fight with Vice President Gore and ACT UP was the US threatening South Africa with action under the World Trade Organization's trade-related intellectual property agreement to attack South African law that made AIDS pharmaceuticals, medicines, more affordable to South Africa's population. So all of these subjective value decisions have been invaded under these rules. And the WTO, agreement establishing the WTO has a particular rule, which is that all countries, this is direct quote, shall conform their domestic policies, regulations, and administrative procedures. Shall conform their domestic policies, regulations, and administrative procedures to the undersigned agreements. So the way this plays out is that there are affirmative requirements in many of these agreements to make standard worldwide a country's policy decisions. And this is that word harmonization. There are many words in GATTese that do not sound so bad until you know exactly what is behind them. Harmonization is one of those words. Whereas we all think of the diversity of standards and choices about what's important as between nations, or for that matter, the state of Minnesota wants to do X, the state of Wisconsin wants to do Y, the federal government's going to do Z. All of the diversity that is the expression of democratic governance and people choosing their priorities that we think of as a blessing of democracy. From the perspective of the authors of this version of globalization, are illegal trade barriers, and are moreover fragmenting having a unified global market. So this whole concept of harmonizing, of standardizing, comes from a worldview where the whole world is one market. Human beings have a value either as consumers or as labor. Nature is a resource to be exploited. And anything that breaks up that unified market and the efficiency of scale that could be achieved for producing to it is itself a barrier that must be eliminated to maximize the good. This is the classic macroeconomic neoliberal theory, right? The problem is, many of what this agreement sets forth as an illegal trade barrier is many of our most cherished elements of these social contracts of numerous countries and sub-federal entities around the world. The WTO pushes to get rid of these differences in two kinds of ways. First of all, there's an affirmative requirement to harmonize. That means either to literally negotiate for a set international standard. For instance, in the area of food, the standards of a body called the Codex Alimentarius is set forth as the legal trade standards for the world for food trade. It sets inspection standards, pesticide standards, etc. The Codex Alimentarius sounds like a stomach ailment to you. You are not far off if you know what these standards are like. It is a very industry-infested standard-setting body in which the consumers have no role or very little now that we've tried to pry our way in with an ice pick. There is none of the accountability or due process like in the domestic standard-setting systems, for instance, in the US. And as a result, you end up with very retrograde corporate standards being empowered under the WTO as the binding international norm. And the implications of this are, for instance, that either any standard that is higher can be challenged at the WTO as an illegal trade barrier. There is a ceiling put in. There are no floors, but there are ceilings of your protection. Or alternatively, some countries just harmonize automatically to the international standards to avoid being considered in violation of the trade rules. So Japan implemented the Codex standards, replacing what were some of the world's highest pesticide standards, and lowered many, many standards, 1,000 standards plus, to take on the Codex and replace their own domestic standards to avoid being out of what was the international trade norm. Similar mechanism, but different, is a phenomenon called equivalence. The WTO in several different agreements requires that countries find different standards to be equivalent if they can determine that they provide an equivalent level of protection, meeting whatever public interest goal. Now the problem is there is no definition of what it means to be equivalent. Therefore, we have concluded that in the US government it is a game of darts. You blindfold yourself, take a bunch of countries and say, let's see what's equivalent. And if it hits a particular country, hey, that country's laws must be equivalent. It's almost that arbitrary, where you have a process behind closed doors where, for instance, the meat inspection systems of the US and scores of other countries are declared to be equivalent, where on the face of it, they're clearly not equivalent. I mean, for instance, just take Canada and the US. The US has inspections for certain contaminants at the slaughterhouse. Canada's system inspects on the farm. When you switch those two systems and just allow free passage and you don't redo the inspection, obviously there's the gap where you don't have the overlap, where the one's expecting it done in one place, the other's expecting it done in the other place, and it means it isn't done. So you have no idea what you're getting. Or Brazil's system, which has company-paid meat inspectors. Now there are many things you can contest with the US meat inspection law. One of those sort of post-the-jungle things that happen is we have government inspectors. So that the boss cannot say, all right, mister, I pay you. You're going to stop that side of beef and get a new job. Brazil has company-paid inspectors. We have government-paid inspectors. That was declared equivalent. The examples go on. It's pretty stunning stuff. And it's happening in an array of issues, from pharmaceuticals to medical devices to cosmetics to worker safety issues, toxics, the entire community right to know standards are being renegotiated actually in several forums simultaneously by a reclassification of all toxic chemicals to be harmonized internationally. So harmonization, equivalence. Then in addition, if all of that pressure to conform is not sufficient, under the WTO there is enforcement. And this is what sets the WTO and NAFTA in a different realm from other international agreements. Typically an international agreement like, for instance, the Endangered Species Treaty or the ILO agreements, those are what are called conventions. which means all the parties sign on to some substantive standard, and then they commit to enforcing it domestically. So everyone agrees what the endangered species are, and they sign a treaty saying they all agree. But the enforcement, for instance, in the US, is implementing of the treaty through our domestic Endangered Species Act, and then we're just agreeing not to import the products or parts of the critters on the list. And every country does their own thing or doesn't. In WTO, that agreement is self-executing, which means it has a freestanding enforcement body. There's a tribunal. And any country can challenge another country's laws as being outside the permitted parameters before this tribunal. The tribunal is created by choosing 3 trade lawyers off a roster, and it sits in Geneva, in the WTO headquarters. And to say it is a kangaroo court is an insult to that type of marsupial. There are no due process rules. There are no conflict of interest rules. For instance, a recent case involved the head of the International Chamber of Commerce, who was running a corporate campaign against a particular law, got appointed to be a judge on the WTO case trying the same law. This was a very well-known guy. This was not an accident. No conflict of interest rules for the judges. It's secret. You can't get the documents. It took us 6 years of litigation in the federal courts so that now Americans can see what the US government is filing at WTO on the American behalf. You still cannot see the other side's briefs and cannot see the rulings until 2 months after they are issued. There is no outside appeal. There is an internal appeal, and the judges on the appellate court are paid by the WTO, which means that either I rule with my paymaster, or alternatively I go with the country who's trying to sack my paymaster. Small conflict of interest problem. And once there has been a ruling, a country has only 3 options. They can change the law to conform with the constraints. They can try and negotiate with the country who's won to give them, in some kind of a trade payoff, the amount of damages that would be cost by not having the law changed. And here's an example. Now, the first WTO challenge, Venezuela says a chunk of the US Clean Air Act regulations that deal with the cleanliness of reformulated gasoline are an illegal trade barrier to WTO. Now, these rules are not discriminatory. This is one of the things about the WTO that's so creepy. It doesn't matter if you treat domestic and foreign goods the same. That is not a protection. It actually gets into the subjective question of how much environmental protection you're allowed to have. So while many people would argue that you wouldn't want to simply say, for instance, in the case of Europe, European farmers can use artificial beef hormones, but we won't allow any imports of that nature. You could be upset about that. But if the rule is we're not selling any beef in Europe that has artificial hormones because our consumers don't want it, and we pass laws because we're not sure what it will do to you over the long term, that stuff, as long as they treat domestic and foreign producers alike, people who are eating should make the decision. Same thing with the gasoline rule, as long as it's not discriminating. Well, in that instance, the WTO said it's not the least trade restrictive way to go about protecting clean air. The good news is they didn't find clean air to be a natural resource. They went on for 6 pages before they were sure if that was a natural resource. This just gives you the perspective of what we're dealing with. And the US decided, after Venezuela claimed that $150 million a year of gasoline that's too dirty to fit under the old rules would be the sanctions, the US decided to cave. And in fact, in 1996, the US changed the US Clean Air Act regulations on gasoline cleanliness and implemented an industry proposal that the actual Clinton-Gore administration, happily for us in writing, had announced would increase air pollution by 5 to 7%, was unenforceable and too expensive. But they did it to avoid paying $150 million in sanctions. So a country must conform or pay, and the bottom line of that is really a slow-moving coup d'etat on democratic governance. I mean, here you have all of the fruits of success of citizen struggles, of laws passed, and you have suddenly another place where all of this gets challenged and renegotiated, and frankly, it can be trumped by a one-size-fits-all set of constraints that are imposed. Now, the only thing that's scarier than the affirmative requirement to harmonize, the threats, the challenges that happen, and the US has had also a chunk of the Endangered Species Act ruled against. We haven't implemented that. Some people are familiar with the case of Godzilla eating Flipper, otherwise known as the Marine Mammal Protection Act case. the case under GATT, implemented under WTO, a variety of others where the U.S. has used WTO to sack progressive laws in other countries. Now the newest thing is threats. After 5 years of seeing the WTO in effect, the record is becoming established. The plaintiff almost always wins. So at this point, if a country threatens the WTO case, there's a country that's rich enough to try and prosecute it, frequently the other country, knowing trade uber alles always wins, just gives up. So for instance, the US threatened the European Union for a very high-level environmental standard that had to do with computer wastes and toxics for recycling in electronics products, saying, oh, this is going to be an illegal trade barrier under the WTO. And the EU backed down and watered down the standard. They never even had to file the case. The US and Japan on behalf of, no, the US and Europe on behalf of Daimler Chrysler are now challenging Japan's implementation of the Kyoto Treaty. They're not going to file a challenge. They just sent them a diplomatic letter with a threat. And now in Japan, the parliament is thinking of what they will do to respond just to the threat. To say nothing of the US threat against Guatemala on behalf of Gerber Baby Foods, claiming that Guatemala's implementation of the UN code, the UNICEF code, and baby milk marketing, so-called Nestle's code, was a violation of Gerber's trademark rights under the Trade-Related Intellectual Property Agreement, and Guatemala dumped implementation of its federal law implementing this international treaty as against all imported baby formulas. I mean, a set of records of these threats is piling up. So, to conclude, after saying all of that gruesome stuff about the 5-year record, the only good news is that actually what was a rather ad hoc system, as our coalition partners in developing countries said to us, who had lived under the International Monetary Fund's Structural Adjustment Agreement, they said, well, get ready, the WTO is structural adjustment for the rich countries. And actually, for the rich countries, we've gotten to see what implementing the whole package of this version of globalization is like. And one of our strongest ways to fight back is simply to educate ourselves about the outcomes, because they are so inherently unacceptable, and to apply the Dracula strategy, which is when you have something very obscure and hidden, simply outing it into the sunshine frequently does not make it fair. And so, as was done to sack the multilateral agreement on investment, aka NAFTA on steroids for the world, the outing of these extreme globalization proposals, and indeed the results of the already in place agreements like WTO, is part of how we build demand for change. Because again, it's just one version of how it is. If it's not working, we can replace it. But it's an educational and political task to build the demand for it.
Pleased to introduce to you Barry Castleman, who flew in 2 minutes before we started, actually 2 minutes before Lori, and is flying out again at 9 o'clock on the dot. So if we have any volunteers who can take him to the airport, I'd appreciate it. Barry is an independent consultant, which doesn't sound very interesting, but in actuality, Barry is one of the U.S.'s experts on asbestos, and he testifies on behalf of workers with asbestosis in the United States in many different trials, and he testifies on their behalf around the world. And he's here to talk a little bit about the WTO's dispute resolution system and the big asbestos case that's in the WTO. Barry Castleman.
Thank you. I, along with other activists, I found my way to the lawyer who was the chief of the European Commission's legal office that was running the asbestos case, because I was dreadfully afraid that we wouldn't know what was going on until it was all over, and got myself hired as a scientific consultant to the European Commission. So I got to see all the documents in the case. I got to see the whole process from the inside, and it's been quite eye-opening to do that. First of all, by way of introduction, let me say that I first became aware of WTO in around 1996 when there were efforts to manipulate a group called the International Program on Chemical Safety. This is based in Geneva, jointly sponsored by 3 UN organizations, and housed at the home of the World Health Organization in Geneva. And there was an article that had come out that I hadn't noticed in '93 in The Lancet, criticizing the IPCS for having chemical industry people all over the writing of their documents. They would publish these things called environmental health criteria documents about specific chemicals. And it turned out that some of these documents were based on drafts that were prepared by companies like Hearst and DuPont that were manufacturers of the very chemicals the documents were purporting to describe the hazards of. And so I didn't hear about this when it was first published in 1993, but later on in 1996, there were strong accusations that the IPCS was putting together a completely loaded panel to write a document on asbestos. And having been in the asbestos wars for many years, I recognized a lot of these names, and in fact, it really was pretty bad. And they were doing the same kinds of things with something called multiple chemical sensitivity. And so I got about 80 scientists to co-sign this, and we published a letter criticizing this whole process of raising questions about conflicts of interest. We sent this letter to the IPCS and its 3 UN sponsoring agencies, published the letter, and this was picked up by the Environmental Protection Agency in this country. Lynn Goldman at the EPA, who was then a high official at the EPA, she's no longer there, ran with this, convened 8 governmental agencies that had dealings with the International Program on Chemical Safety, and got a letter out of the State Department detailing 12 ways that the IPCS could clean up its act in terms of the conflicts of interest in the preparation of its reports and the selection of experts to write them. Unfortunately, this was then picked up by the World Health Organization. They developed something called Draft Declaration of Interest Guidelines with a 1-page form that was half decent, and they're still working on that, last I know. But with the IPCS, later with the World Health Organization, there was another example with the European Office of the World Health Organization putting out this report on asbestos and health, which looked like it was written by the asbestos industry, and probably was. We managed to get that suppressed after it was published by the WHO. The World Headquarters Office moved in on the regional office and withdrew that report. And so it's now about to be reissued, and we're holding our breath to see what it's going to be like. The International Labor Office, a similar thing happened with the asbestos industry, sponsoring training sessions in Brazil and Mexico for the ILO, for doctors to learn about asbestos and disease. The asbestos industry used a front group called the International Fiber Safety Group, which was based at the Asbestos Institute in Canada, and it was nothing but a front for the asbestos mafia. I mean, there were no other manufacturers of fibers, minerals, and materials involved. And they were sponsoring this. Next thing you know, they send this report into the ILO, and the ILO then circulates the report for people to comment on before it gets published as an ILO report. And it's, what do you expect? So we got that stopped after 9 days of, by this time the internet was around to help us. This was 1997, and within 9 days the ILO decided they weren't going to publish that report. But this is all because of the World Trade Organization, that suddenly there's all this interest at these international organizations. And at first I really thought we were at a complete loss to fight battles in places like this. It's bad enough trying to win anything in Washington. Try going to Geneva. So anyway, we found that we could put things like this together. Anyway, let me now tell you about the WTO case, which the decision of which was just announced yesterday confidentially to the parties, and so it's absolutely not supposed to be disclosed to the press the way it was by the Canadian government yesterday and various others in Brazil and Australia yesterday. And this is what the case is about. It's a challenge by Canada to bans on asbestos by other countries. They challenged the French ban as the target case, and the real question is, do countries have the right to ban something like asbestos under this new rule, this new world of free trade that we live in? And this was being brought to the lordships at the World Trade Organization to figure out. Canada's argument was that this is an unnecessarily severe, draconian way of dealing with the health hazard. That if you have worker protection standards and consumer protection regulations, then that's good enough. You don't need to ban asbestos. There are lots of other hazardous things that we continue to use in society. Why pick on asbestos? And so this was the argument they made, disregarding the fact that asbestos had, by the 1999 when this case went forward, been banned in all the leading European countries The United States tried to ban it, but some fancy footwork by the asbestos industry lawyers overturned the ban, with some help from the Canadian government even then. And that was 10 years ago. So now this case goes forward, and the question is there such a thing as controlled use of asbestos? And are the people at the World Trade Organization there who are very well trained in economics and don't even understand how to pronounce the tumors that asbestos causes, much less the medical literature that's based on it? These economists are going to be the judges of this case. And the real target of the case was the third world countries, where all the asbestos being exported by Canada now goes. Canada exports 95% of all the asbestos they mine. So they're dumping this on third world countries, and they're going to the World Trade Organization saying controlled use is possible. Look, it's possible in France, and we're not going to talk about these other countries because this case is about France. Only if they won this case against France, it would have had precedent importance affecting all those other countries. So what the case is really about and what the case was, strictly speaking, tried on are two different things, and it raises serious questions about what the WTO is doing and how it's doing it. Even the United States, cheerleader for free trade that the United States is, was against Canada in this case. The United States said that individual countries should have the right to ban something as bad as asbestos. Hormones in meat, well, it's okay. But asbestos, really, that's pretty bad stuff. We kind of know about asbestos. I had to explain to the lawyer at the U.S. Trade Representative's office that when asbestos was introduced, they didn't know it was bad either. And it took 20 years before it caused disease in people because of the latency of asbestos-related disease. But liability has just about ended the use of asbestos in the United States. The lawyers have done a wonderful job. The hell with the Environmental Protection Agency, OSHA, the Food and Drug Administration, give me a break. But the lawyers shut down the asbestos industry in the United States. They did a wonderful job of that. Nobody can get insurance to use asbestos in products. The workers are scared to death of the products. And it's down to about 3%, even with the ban overturned. It's down to about 3% of what it was 25 years ago, U.S. asbestos consumption. So this is the reason why the United States government is on the side of the angels in this case, because it didn't step on any big corporate toes. They don't care about asbestos. They're all making things out of other materials in the United States today. They can't sell asbestos products anymore here. It's the leading cause of occupational cancer in the world. In the third world, it's used in making asbestos cement building panels. You see this corrugated gray roofing all over the buildings, on the tops of small buildings. That's asbestos cement. Asbestos cement pipes and water tanks, storage tanks are also used widely in the third world. It's also used in brakes, not in the leading countries of Europe where asbestos is banned, but in more primitive countries like the United States, where it's still legal. And still used in some cars, although not in most. Consumption of asbestos in brakes is down about 90%. So that's almost finished. So the WTO decided they would select some experts. They didn't ask the people who were nominated by the international organizations like the World Health Organization whether they'd ever done any work for the asbestos industry, even though the European Commission urged them to ask the experts about this. So I had to deal with 34 experts with CVs, including hundreds of publications each, and try and figure out who the good guys were, without asking half of the other people that would know who they were, because they were also nominated, and so they couldn't be dealt with in any of these investigations. But I had probably 2 weeks to figure this all out, and make comments along with the other scientists working for the European Commission on who was honest and who shouldn't be allowed. The WTO also went to the International Standards Organization, the ISO, that was mentioned just now. This is a totally industry-dominated group. When I tried to find out what an ISO standard for asbestos cement construction materials was based on, they couldn't provide any documentation to explain why it was okay to use circular saws and lathes on asbestos cement construction materials without dust control, according to the ISO standard. They couldn't provide any data, any published articles showing the measured levels of exposure, which would have been high from doing those kinds of things, which they said were okay without dust control. And when I asked them for the authorship of this standard, they couldn't produce the names of the people either. It was obviously the asbestos industry. Canada objected to people from the Collegium Ramazzini being appointed as scientists from among the 34 nominated scientists from international organizations. The Collegium Ramazzini is a respected group. It was organized by Irving Selikoff, the leading scientist in the second half of this century in dealing with the asbestos problem in the world. One of the many things that Selikoff organized was this the Collegium Ramazzini. It has among its members many of the leading experts on asbestos in the world. There are 180 scientists in the Collegium. And none of them were selected by the WTO because Canada objected because the Collegium had issued a statement that asbestos should be banned worldwide. And that was published last year in 5 journals because there were 5 journal editors among the Collegium membership. And one of the people that was attacked by Canada that shouldn't be selected because he was on the editorial board of one of those journals, believe it or not. I mean, if you added up all the editorial board members on all those journals, you'd eliminate half the people who are leading experts in occupational health in the world. WTO finally did select 4 experts, and one of them was an expert that had been nominated by Canada, but they made a mistake. They nominated Peter Infante of OSHA, who had authored an article saying fibrous glass causes lung cancer, and they thought they could use Infante too. Canada finally defined what they meant by controlled use 1 month before the special meeting of the scientists. They held a meeting, they brought 3 scientists in from Australia, Infante from the United States, the lawyers and the consultants from the 2 parties, so there were 36 people in the room. The US government wasn't allowed in the room, the International Labor Office wasn't allowed in the room, the media wasn't allowed in the room, just these people. And so, but just before this, a month before, Canada finally defines controlled use. And it's pretty amazing what they say. First of all, they say that Canada has advocated the use of chrysotile asbestos in high-density products. Textiles are not of that category. Well, it turns out that practically the only use for the long-grade, most expensive asbestos fibers is asbestos textile products, which are only made now in countries where asbestos is hardly regulated at all. And so it makes me wonder, where do they sell the long fibers now that they're not selling it in textiles, they say? And what system do they have for really making sure they're not exporting their asbestos to companies that are going to use it to make textiles? They didn't say anything about that. It gets better. With regard to downstream use, they say that you have to have a permit, an import permit to use asbestos, their asbestos, in the country where you operate, and this will be withdrawn if the company does not meet the following commitments. And these commitments include to provide products cut to specification and establish centers equipped to cut the products to size, where persons doing the work are properly trained and protected. So imagine this. You've got construction industries in places like Sao Paulo and Bangkok, and the construction companies in the middle of their construction projects, when they need to saw up a sheet of asbestos cement, they're going to put it on a truck, stop what they're doing, and wait for that truck to sit in traffic in Sao Paulo, trying to get to one of the however many regional fabrication centers that the asbestos industry has kindly provided to cut up these sheets of asbestos cement and then ship them back to the construction sites. Needless to say, this has never happened in the world. Never has the asbestos industry provided such a thing. It gets better. To police downstream users, you heard it right, in cooperation with the government. They proceed that they are now prescribing, the Canadian government is prescribing that the product manufacturer visits, monitors, and reports on the performance of downstream users at regular intervals. So they're going to conduct surveillance on their customers, and they're going to turn them into the government if they're not using asbestos right. Needless to say, this has never happened in the history of the asbestos industry either. I wrote my doctoral thesis on the history of the asbestos industry. That's why I'm trying. I can assure you, it's never happened. As for reporting the violators, it sounds like a movie spoof. You can picture Peter Sellers running an asbestos company and calling up the government every time somebody uses the asbestos wrong. It can only be presumed that the lawyers for Canada were encouraged to express such fairy tales to the World Trade Organization as national policy because the document was kept confidential. This never had to be disclosed to the people of Canada, that their government was expressing its foreign policy on a forum like this. They never had to be challenged, never had to be discussed at home. They said that without fear of contradiction, without fear of paying the political price of an open society for dealing with that kind of lies at the WTO. Canada also said that France had economic motivations for banning asbestos that were absolutely groundless. In fact, one of the major substitutes for asbestos is cellulose, which France imports 10 tons a day from Canada. Canada also said that asbestos fiber substitutes are too hazardous or too poorly studied to be used to replace asbestos. Better the devil we know argument. This was rejected by a very good report by the UK Health and Safety Executive. Scientists wrote a report that was timely in its publication, comparing asbestos to the 3 major substitutes and saying the substitutes were much better to deal with. Process weaknesses at WTO. The decisions are made by faceless bureaucrats. You had these 3 monkeys sitting up there in front of this thing. These economists, they're falling asleep after lunch. You know, and we're holding a scientific hearing. These guys are trained as economists. I don't think they could understand half of what they were being told. They did not disclose their ignorance by asking a single question. But they sat there. I think they must have taken some kind of medication later in the afternoon because they were sitting up listening, being tried, true diplomats of the trade world. They had no legal backgrounds, most of them, no experience as judges. There are no scientists practically in the WTO. It's all economists trying to outdo each other in justifying trade overall. And this is what we're dealing with. European Commission wants to abolish the panel system. They pick these 3 guys' names out of a hat, eventually negotiate down out of a list of 140 names so that the 2 parties will agree on these retired or whatever trade diplomats being the judges. And the European Commission wants to have full-time judges the way they do for the appeals of these cases. So the appeal process is 6 months after the case is decided. There are only 9 lawyers in the EC legal office left to fight all this corporate crime. And left to fight not just Canada, but to fight can you imagine what they're going to have to deal with when the genetically modified foods case goes to the WTO after the election? Can you imagine all those industries and all the lawyers for the U.S. government? They got 9 guys in the office, nine lawyers in the office of the European Commission that's going to have to fight that case. Anyway, we won the asbestos case. After all 4 scientists said asbestos should be banned, there are safer substitutes, there's no safe level of exposure, and controlled use is a joke. So they blew off the Canadian argument about controlled use of asbestos being an alternative to a ban, and the WTO bought that. That was announced to the parties on Tuesday, and as I say, it's already hit the press in various forms. And now it remains to be seen whether Canada will shut down the asbestos mines now that even the WTO has said that controlled use is ridiculous, and to talk about controlled use in the places where you're really selling that stuff is even more ridiculous. So that's it.
Now, Lori and both Barry have talked about the big picture, WTO rules, how it works, how the dispute resolution system works, and Mark Ritchie, who is the president of the Institute for Agriculture and Trade Policy, and who you all probably know better than I, is now going to bring it home and talk about Minnesota.
So this is fabulous to hear these 2 presentations sort of laying out this whole scheme, and I kept thinking, and when Barry was describing the whole process, just how expensive, how complex this whole, so-called free trade procedure. And my first thought about that was for the third world. In this case, we're dealing with the European Union, which is arguably bigger and richer than the United States. There weren't a lot of lawyers, but I mean, they have the financial capacity to fool around with something like this. Imagine third world countries, the countries of the Caribbean, which the U.S. has been attacking on the question of bananas, and third world countries. And to bring it home, imagine like the state of Minnesota, and I'll tell you one story about the state of Minnesota and the WTO that is part of this whole harmonization process that can begin to give you some impression of how this can affect us right here at home. I think in 1987, 1988, the European, at that time as European community, had a lot of problems with effects on young children, especially young girls, with hormones that were being used as stimulants in beef. And they took the decision to ban the use of those hormones in their own production. And they said that imported beef would no longer be allowed that had used these hormones after 1 year. They gave all the countries of the world 1 year notice before their beef would be controlled in the same way. Well, in Minnesota, you know, we have a lot of dairy farms, and we don't use beef growth stimulant hormones. And I was at that time working in the state government, in the Department of Agriculture, doing the trade work. And we thought, God, this is great. All of a sudden, Europe is banning the import and the use of hormone-treated beef. So there's going to be a market there for Minnesota's beef, coming from mostly dairy cows, which isn't treated by hormones. So we were getting all geared up. And a couple other state governments, Texas and Idaho. And then all of a sudden we get a letter from the U.S. government, from the USDA. Clayton Yoyer at the time was the secretary, saying, hey, wait a minute here. You're not going to go sell hormone-free beef to Europe. No, I'm saying, what are you talking about? This is a real opportunity. Some of you remember the 80s, what a terrible crisis it was for farmers. And the USDA said, listen, you know, we're not going to allow any states to approve and ship beef that's hormone-free to the European community because, number one, it would imply that their ban was legal, and number two, it would begin to alert American consumers that there may be some problem with these hormones. And in fact, they went so far as to threaten the Secretary of Agriculture of Texas. You know, they have you know, commissioners. We had a commissioner of agriculture in Texas, the secretary, who at that time was Jim Hightower, who a lot of you know, with prosecution under something called the Logan Act, which is an early 1900s sort of cavorting with the enemy, espionage, and economic treason, if he pursued this process of trying to sell hormone-free beef. So in the drive for harmonization, even small entities like the state of Minnesota can get caught up. And when you think this is about free trade, you just have to remember that in fact it's not about free trade. In that instance, it was very, very clear. There wasn't a ban in Europe on the import of beef. There was an embargo by the United States government on the shipment of hormone-free beef to Europe. And the reasons, there were a variety of reasons, as I mentioned, and another reason which they finally admitted was that the U.S. was the place where the companies were located who were manufacturing those hormones. And they wanted to extend their use. Well, that was 1987 and 88, and this is now nearly 13 years later that this beef hormone case has wound its way through the WTO process, and some of you know the story. The U.S. has won based on codex and other standards, saying that Europe does not have a right to maintain a ban on imported products. And Europe, at the moment, is being subjected to very high countervailing tariffs on a number of their products that are aimed at trying to force them to allow the import of these hormone-treated beef products. Well, this little story at that time was a kind of a tip-off to me about how these international institutions, which that time it was the GATT, the General Agreement on Tariffs and Trade, were beginning to be the big factor in what we would be able to do and not able to do, and as we were trying to address agriculture policy. I wasn't thinking very much beyond agriculture at the time. In fact, our biggest focus wasn't on so much the hormones and those kind of issues, but it was just on the survival of family farm agriculture in the context of that crisis. And we would go to Washington with, you know, proposals, policy proposals, ideas for changing federal law. And every once in a while we would get a hold of somebody who was kind of sympathetic in the USDA or over at Congress. They say, you know, that's a really great idea. Supply management, balancing supply and demand, whatever, but we can't do that because of the GATT. And you know, this was all happening at a time where things like the GATT and these international institutions weren't so well known. But the idea and the process was something that people were very familiar with. You know, people would try to pass a law in their county to protect their water or something like that, and the corporation would go running down to St. Paul to try to get it overturned. Or Minnesota would pass a law like a state Superfund law, and 3M would go running off to Washington to get that law overturned. So that process of corporations running off someplace to get somebody to overturn, to dismantle, to deregulate a rule, a law, a standard, was something we were familiar with, but we were only at that time beginning to notice that this was happening at an international level. I can remember coming over here to the law school and talking to Bob Hudak, who's a wonderful professor here. In fact, he also has a sense of humor outside of his office upstairs. You know, on his name plaque, he has the picture of the three faceless bureaucrats from the ad that was developed about this. He's a very, very interesting guy. But he was chief counsel at the Tokyo round, which was one of the most important modern rounds of negotiation. But I was talking to Professor Hudak about this, and he said, yeah, you know, Ronald Reagan, he came to office, and I don't know how many of you remember sort of political history, but there was a time when we thought that the White House would always be controlled by Republicans and the Congress would always be controlled by Democrats. That was kind of the thinking. And for the Reagan administration, they began looking for all the different ways they could write laws without the Congress, because they had a hostile Congress. Not that the Congress didn't have its own interest in line with Reagan on many things, but in general, the White House, the Reagan White House, began looking for ways to get around the normal policy-making process. And it turns out that the WTO process, as you've heard it described, is one of the most effective ways to do that. And especially on agriculture, they found that using that WTO, the GATT process at that time, was the way that they were going to use to try to write agriculture policy completely in line with the interest of the grain companies and the processors. And at that time, it was very clear that those policies that they wanted to use the GATT to implement were going to be devastating to Minnesota family farmers. And so people in Minnesota started trying to pay attention to what was going on in this process, this globalization and harmonization process. In fact, I think it was in the spring of 1989, the trade ministers from the United States, Europe, Japan, and Canada, it's called the Quad. They're kind of the big power force inside the GATT. They meet once or twice a year. They had one of their annual meetings up in Brainerd, Minnesota at Madden. And so I think it might have been the first kind of demonstration against the GATT. Was up there, a bunch of farmers came in from Canada and Japan and from Europe, and there was a little demonstration and there was a counter conference, and that helped really fuel a big demonstration that was in Montreal that following winter, where the GATT gathered to look over what they had done, and a whole lot of people showed up in the streets on a very cold night. But what was motivating the folks who were beginning to see and be aware of this threat was in fact this process that we've heard described tonight so well, which is that folks had fought long and hard for environmental protection, consumer protection, laws to help family farmers, for local laws to help small businesses or minority-owned businesses, whatever. And it took a lot of work to do that. And they were beginning to see that what was being put in place wasn't so much a set of rules, although that was being negotiated, but was a process and a procedure for overturning and changing rules. And they began the process of understanding of this harmonization, the globalization, and beginning to see all of its potential ramifications. So here in Minnesota, this little caper with the beef hormones was only the beginning, because there were a lot of other specific instances for residents and citizens here in Minnesota. you know, we're a state that often has this dilemma of passing worker rights or environmental protection or other progressive laws. And we got a lot of people in the legislature say, oh, we can't do that because we'll be an island. You know, we can't have a decent minimum wage law because they'll just move the jobs to Wisconsin. Or we can't do this or we can't do that. This whole process, but often Minnesota will move ahead. Take a tough decision, create a higher standard, raise the minimum wage, take a kind of courageous political position. And we know that that eventually draws and pulls other parts of the nation. California has done this on air quality standards and environmental regulations for a long time. That process by which a unit of government, like a state, can move forward and eventually pull things up has been critical to the progressive tradition, the progressive process of our state. The whole procedure of harmonization through globalization is really about attacking that process, because it's about saying that you cannot go above this ceiling without being threatened, without being challenged, without in fact being dragged down. The state of Oregon tried to get out in front on helping its small businesses. It had a particular law which gave a different kind of tax standard or a tax rate to smaller wineries and breweries as opposed to the big global multinationals. The WTO ruled that that was a discrimination against large companies and forced them to change that ruling. Every time you turn around and you begin to see where people are rising up and passing new laws or taking steps in some way to try to build their own communities or protect their health or protect their families, and they begin to move forward with progressive policies, you can begin seeing the forces that are opposed to those changes beginning to circle the wagons, beginning to call up the U.S. Trade Representative, begin calling up their counterparts in other countries, and you can begin to see the process. There's been a long history of this struggle of people trying to improve their situations, change their laws, make their lives better, and the corporations and those who profit from the current system and who are opposed to those changes being able to go and use the government to stop it. What's changed in the last decade is now these corporations have the ability to go use a very big club, a very big stick, a global stick called the WTO. It's not the only one, the OECD and others, but it's a big one. And they'll be able to bring that to their side of this fight. So in addition to the fights that we have to protect our health and our family farms and our jobs, we not only have the specific fight over those standards or those laws, we also have to fight the system that's allowing the WTO to be used as a weapon on the side of those who would stop this kind of forward process. Minnesota's been active. A lot of the people in the room have been at this for years. We have to continue to be active. We have a lot of things to defend, but we also have a lot of new ground and new progress that we have to go forward with. At the end of the day, part of the discussion for me is I think about how few years of life I have left to work. I think, am I going to have to spend all this goddamn time on something like asbestos, which we've known for 100 years, when we have so many other really pressing problems to deal with? If the WTO is about burning up this much human energy on something that for 100 years we've known is a murderous product, we're going to have to get rid of the WTO to have the energy and time to deal with the things that we need to deal with today. Thank you.
Gary, I thought that the WTO had an exemplary record of striking down any concern for human health. What happened? What'd you do?
Everybody makes mistakes. No, I think it really was the Seattle thing that, that coupled with the fact that this was a cheap way for WTO to look good because there were no big corporations to give a damn about asbestos anymore. I mean, the old asbestos mafia is gone. They've diversified into other products, the big companies, and they've sold it off to the former mine managers to run for a few years, for 3 years worth of profits, just to wash their hands of it. And so you don't have any big corporations that are still in the asbestos business. And it's an industry that's finally started to go down by half in the 1990s, just when I gave up expecting that to ever happen.
I think also just to add to that, it shows the political potentials of something as outrageous as the asbestos issue being something that could tank the whole WTO. Because I think part of why this decision, why, as someone put it, they looked for a way or they made a mistake, was in the name of self-preservation. Because if the WTO sacked something so obvious that everyone knows is the right thing, it's the WTO that's going to take more lumps than anything else, would undermine its legitimacy, be very revealing. And on several occasions of highly politicized potential decisions, the WTO has backed down really to avoid revealing how rotten it is, or as Mark said, to avoid more people saying it's got to go. And I think it was political that they threw the case.
In the back room?
I wondered if you could comment on asbestos in gardening vermiculite. That gardening vermiculite is made up of asbestos.
Well, W.R. Grace is no longer mining that mountain. And I don't know if the vermiculite from other sources is similarly contaminated. The W.R. Grace deposit in Libby, Montana was originally called the Asbestos and Vermiculite Company. So it was well known in 1919 that the stuff had asbestos in plenty. And I don't need to go through the litany of that cover-up. But I don't know about vermiculite that you buy in your gardening stores or kitty litter these days. I can only hope that the companies, taking account of the potential liabilities, have found cleaner sources of vermiculite.
Yes, ma'am.
I have a question. It seems as if there's a bit of an impasse because I'm just observing a lot of what's going on the last 6 months in Seattle and at Seattle. It seems as if there's no middle ground in terms of, or maybe this doesn't get the media play, in terms of, well, if not the WTO, if not the GATT, then what? What's the positive agenda to sort of, if we're sort of all agreed that we really want to lift people up out of poverty in some way, and if trade in whatever form is a good method towards doing that, how do you sort of reform the WTO while keeping in mind some of the clear goals of environmental and labor protection, while not further alienating or marginalizing developing countries? And how do you allow more transparency without necessarily marginalizing them again because they can't also afford expensive lobbies, replacing the expensive lawyers with expensive lobbies? And I'm just sort of at a point where I just don't see what's next.
Well, certainly it's a very complicated question with a lot of potential foibles. But one of the first steps that seems pretty clear, on which there is a broad NGO consensus that includes northern and southern groups, is the notion of reclaiming the space that has been taken away to work on the policies and the challenges in our governments around the world, that the space of which has been occupied by the WTO, basically putting the handcuffs on our policymakers. So the next sort of approach towards moving towards rules we could be happier with is an approach of WTO shrink or sink, which is to say to whack back the parts of the WTO that have infested, invaded all of these subjective value decisions. So for instance, the trade-related intellectual property agreement is a classic example. That whole agreement should just be ripped out of the WTO. It is an inappropriate place to have those kind of decisions made. And by pruning back some of those excesses, Group C is the first step towards creating a political space, which ultimately, an answer is some combination of setting up a floor internationally of conduct that corporations, multinationally operating corporations, would have to meet, with then no ceiling, so that you would have the ability to go higher. There's a much longer term fight, and in the shortest term, the thing that seems achievable is to prune back the excesses of that institution and fight back for a democratic space.
Go ahead.
Wasn't there a joint resolution 90 suggesting that the U.S. question or eliminate approval of WTO in America?
There was legislation, in the implementation of the WTO, there is a provision that requires every 5 years a review of the WTO, and there is the allowance for any member of Congress to have put on the floor a privileged resolution, i.e. it gets on the floor for a vote, to withdraw from the WTO. The groups that are criticizing the WTO, as well as the members of Congress who voted against it in the first place and have led the fight against it and came to Seattle on our side, have been monitoring the WTO, have been bashing the WTO. But after doing a political survey of our situation, we came to the conclusion that this was not the time to try and pull that resolution. In part because you would need a presidential veto override majority, i.e. 2/3, to actually succeed in changing the policy. It would have to be, both houses would pass it, the president would sign it. So even though you get on the floor, you couldn't really accomplish anything, and if you lost, it would be a setback. So in fact, the groups that are the leading groups criticizing the WTO, or those who seek to abolish it, aren't working on that resolution at all. And in fact, all of the members of Congress who've been leading the fight against the WTO didn't put it in. In fact, one Republican, actually a libertarian from Texas, despite being begged by the critics of the WTO not to put it in, did introduce the resolution instead of languishing. And it's not something that the groups or the members of Congress who've been fighting it are really focusing on.
Yes, ma'am.
Mark, I wonder if there's anything comparable to what the Women's Consortium is able to do by sending out a bulletin each week with legislative alerts with who's got what law out and who to call and so on to really get citizens access into the system. How about a column in the newspaper, the business section?
Yeah.
Well, actually, there is an excellent publication called the Harmonization Alert, and there's piles of them out front. And this is a publication of our project. And what it does is it tracks the Federal Register, which is the place where all agencies put their rule changes. They put them into a big document called the Federal Register. And so we track the Federal Register. We look for agencies that are involved in international harmonization activities and when they're thinking about changing our rules and regulations because of that. So you can go to our webpage, which is www.harmonizationalert.org, and you can sign up to get Harmonization Alert via email or by the mail, and we'd be happy to send that to you free. So,
Would you say that again?
www.harmonizationalert.org. Okay, Mark?
There are also a lot of different listservs, both listservs related to the harmonization project out of Public Citizen that track in worker safety, environment and food safety, harmonization and regulatory activities, but also for folks who are interested in engaging in the broader political struggles and globalization. There are several big listservs, I know there's some people here who are on them, that lists the different campaigning opportunities with Congress. Plus, if I may introduce Larry Weiss, who directs the Minnesota Fair Trade Campaign, the model fair trade campaign amongst the state fair trade campaigns. All the other states should emulate what Larry and the Minnesota Fair Trade Campaign are doing, which is a cross-sectoral coalition locally of local environmental, consumer, labor, and other community groups, all working together for a pro-fair trade, anti-corporate globalization agenda. And we're lucky to have Larry. In some other states, there are less permanent coalitions. So not only can you get a listserv, you can get a live human being.
Yes.
Do you think a crash of Wall Street or the new economy could help dismantling the lobby for WTO?
Feel that one?
Well, you don't really want to pray for a crash on Wall Street, but one could speculate that if there is this level of opposition that the national public opinion polling shows, both opposition to this version of globalization, but also concern and anxiety in this era of growth and low unemployment, It does not take much to speculate what would happen when there is a turnaround. In fact, it is fairly spectacular that given the background economic conditions, the level of opposition and concern exists. So while I wouldn't do a cause and effect, I would say that the critics would have yet more potential constituents.
There's another thing that might blow up the WTO, and that's if the United States files a mutant food case over there and tries to make the Europeans take genetically modified crops. Because the lawyer for the European Commission told me, we were sitting in Geneva eating lunch, and he said there'll be demonstrators out here. If they do that, they'll be coming from all over Europe. He said that could blow up the WTO.
So other hands over here. Questions? Questions in the back?
I wasn't here at the beginning. I was wondering, is this classified as, and would this be considered on international legal apparatus? And then if so, are there places where decisions of these various administrative bodies are reported? Along with that, are there manuals of their administrative rules?
Of the harmonization bodies?
No, WTO regional.
Is it
Well-
binding legal apparatus?
It's about 4 different questions. The answer is, as a matter of U.S. constitutional law, the Congress, by approving the Uruguay Round Agreement and implementing legislation thereof, and is doing the same thing for NAFTA, made it a part of binding U.S. federal law. So yes, it is legally binding. It is not like a treaty. It does not trump federal law. Federal laws have to be challenged, but it automatically trumps, without any dispute required, all sub-federal law, so state and local law, automatically.
Under what clause? Under what area? Clause?
Basically, the agreement is negotiated under the 1933 Trade Act that is negotiated and readjusted in 1974, which was the creation of Fast Track. And the Fast Track implementing legislation code allows the yes or no vote with no amendments of a trade agreement and its implementing legislation, which is the procedure under which the Uruguay Round was approved. And then the Uruguay Round becomes U.S. federal law, which I can give you the citation to, including the entire agreement. But the bottom line is it's some delegation between Articles 1 and 3 of the U.S. Constitution.
And I'm very glad
See, Ma, there's a reason to go to law school.
I'm very glad you asked that question, because I'm hoping at law school there might be a few law students here, and so I brought the World Trade Organization agreements, the 2 binding agreements, the food agreement and the products agreement, if anybody would like a copy of those.
And also, I mean, while unfortunately, in fact, the WTO specifically does not come with a user's guide. In fact, it is like a very complicated thing that intentionally does not come with a user's guide. We have tried to do some translation out of GATTese. So we have the pocket trade lawyer. Yes, all of you can avoid the 3 years of hell that I went through, and instead just get the Reader's Digest form. And what we basically did is, first of all, we defined all the damn acronyms because it's an alphabet soup. But also, we put in the so-called tricks of trade, which is to say all the sneaky weasel words that are in the international trade agreements that seem like a normal word in English, like necessary, but that actually have an inch of GATT jurisprudence underneath them. That means a whole variety of regulatory things. We have translated out into clear language so that armed with this, you too can read GATTese. And we have a bunch of these available.
Send it to you. Yes, sir.
I just want to ask, just recently, Mark and Lori might be able to answer this question. The status of the situation, just recently, Minneapolis City Council had passed an agreement, selective purchasing agreement with Burma. Our supposedly progressive mayor, was supposed to be, has vetoed that, if I'm correct. And I'm wondering, you know, I was hoping they would go through with it, take it to the fullest, highest level possible, and challenge the illegality of this body over local decision. Do you know the status of it? Do you have comments on it? What's going on nationally with those agreements?
Well, the most important single instance which is directly related is the state of Massachusetts, which took its law, which was written for the South African boycott, changed South Africa to Myanmar, Burma. And then that law was eventually challenged by a set of corporations, and it has been ruled illegal, and in lower courts, and it's now in front of the Supreme Court. And I think arguments have been made. I think arguments have been made, and we're waiting to hear what's going to happen. At the same time, our U.S. federal government has been intervening, I know in the state of Maryland, in the state legislature and other places, saying you can't pass that law because it is in violation of our GATT or WTO obligations. We even had a similar case. Gray Davis, the so-called progressive governor of California, vetoed a law that would have given purchasing preference to California-produced products because saying it was in violation of our WTO obligations. And so we're beginning to see more and more this phenomena Lori described well, which is just the threat. I mean, who called up the mayor, and does this person live in town? And do they represent the people who put her in office? And in any case, if you've got principles about human rights and how the world works, and somebody calls up and says, well, you know, you're going to get your hand slapped in Geneva. I mean, I've been out of town for 3 weeks, and I actually didn't know this had happened until earlier today. I can't say how shocking I find this. And I think in general, this is much more the point than the specifics of all the 900 pages of rules. It's this chilling effect. It's this where decisions made. It's this what happened to the democracy. And I would argue, I'm going to go back to your important question, because I spent a lot of time on international issues my whole life, and was part of the group that got the World Health Organization and the UNICEF to pass some global codes to stop Nestle, and, you know, working on that whole process. So in a way, I've spent a lot of time thinking about the necessity and the importance of global cooperation and global rules and, you know, the whole procedure. And it's in my experience that it's this way in which the WTO, the IMF, the World Bank, these other institutions have been hijacked and are being used for things like stopping the city of Minneapolis from taking an important position, is in fact the reason why these institutions, which are part of a much larger system, are going to blow themselves up. And so, in a way, in the international debates about this, I think when people start to talk about these institutions and the importance of having rules, because if you don't have rules, you just got the biggest corporation doing whatever they want to, or whatever. We're going to lose these institutions because of the way they've been hijacked and they've been used to manipulate and to overturn laws and do all the things they're going to do. And I think this Burma case, if it's down at the level of our mayor taking some phone call from somebody from some other place and deciding to veto, a resolution at the city level, we're beginning to see the micro effects of this global system, which is why everyone came to Seattle.
And can I just follow that up real quick? What previous decisions in the past would have been negated through this process? I think the public.
Well, the South Africa, the direct one is the South Africa boycott. But the passing of the various resolutions by state and local governments prohibiting, purchasing from companies who did business with the apartheid regime, or all those kind of things. Well, the Burma laws that have been challenged, all they did was took white out and took South Africa out and put Burma in. I mean, these were exactly the laws. And the people of South Africa have been very articulate about the power of that and the importance of that in getting rid of the apartheid regime. This is not, some kind of fairyland discussion about some kind of marginal thing. These are very central issues. We pay taxes. Somebody in Geneva is telling us what we can and can't do with our taxes. There have been revolutions over this kind of thing.
Well, and to that end, it strikes me that in this instance, given the folks you've got here in the city and the folks who thought they elected a fairly progressive mayor, and the background of this city's involvement in the anti-apartheid movement, it seems like it'd be an interesting campaign of accountability, frankly, to keep on the mayor about having done this, because you don't know who the outside call was. but it sure as hell isn't the outside person's tax dollars that are gonna be sent to support that regime. And it's really, we gotta fight back on these particular instances, because the principle of that is in the government procurement agreement. It basically says you're not allowed to look at any non-commercial conditions. So what plays now for Burma, or would have gone for apartheid, frankly also goes for any other human rights or environmental condition. We will only procure sustainably harvested, paper made from sustainably harvested wood. We will not deal with the regime in Nigeria. All of those issues are the same issue under the government procurement agreement, having to do with how you can use your tax dollars. So the fight back on this one might be a place to take a stand.
Larry?
I want to dwell on this for a second, because I think this is fairly important. It was quite a shock to a lot of people as to what happened. And it's important if you read the mayor's statement about why she vetoed it, because she essentially said she does not believe that foreign policy should be made at the state and local level. This is the same mayor who, as a council member, was instrumental in passing the legislation from the city of Minneapolis regarding apartheid, at which point she clearly did believe that people at the state and local level should be involved in foreign policy. And it's one part is exactly what you say, Mark, the call that says, you know, you can't. The other side, and I don't think it should be missed, was the announcement in yesterday's paper that she'd been appointed as co-chair of the Democratic Platform Committee. There was some appearance of quid pro quo here, or at least that something couldn't happen if something else didn't happen.
Yes.
I'm a member of the United Steelworkers of America. I work in a printed circuit board manufacturing plant. And one of the reasons why I came to this meeting tonight was because yesterday at my union local meeting, the recording secretary read a letter that was going to be sent to the district director of our union from a woman who was making an appeal for the union to begin to put together the resources that we're going to need to start looking at what kinds of effects on the workers in the plant are the chemicals that we're working with and the materials that we're working with to manufacture printed circuit board equipment having on the people who work in the facilities that we organize. And this is a really important question. It's, first of all, we know that we work with chemicals that have deleterious effects on both human beings and the environment. We've known that for a long time. We don't know the extent to which they actually affect people in the plant. We don't have access as a union to the kinds of resources that we need to do studies to actually make some of those determinations. But there's a lot of anecdotal evidence around the plant. You work in the plant, everybody's got cancer. The rate of cancer among the people who work in these plants is unbelievable. It seems to me that one of the things that we need to forge, and I know there's a lot of people from the environmental movement sitting in this room, and it's one of the reasons why I'm raising this. We need to forge a very concrete alliance between workers who are working in these manufacturing facilities who need access to the kind of educational resources that can be provided by people who have been studying this kind of stuff all their lives. We don't have it right now. You know, the union movement used to be organized in such a way in the old days of the Knights of Labor that there were study groups, and we had, you know, workers were organized to come together to study various topics and subjects that were of interest to them and to their lives. We don't have those kinds of things anymore, but we need them. And one of the reasons why we need them is because the actual life, the life of our workers is actually being affected. There are lots and lots of other workers in the area who are finding ways to stand up against the conditions that lead to injury, even lead to death. One of those groups of workers is out of the Dakota beef processing plant. And on June 1st, they organized a sit-down, and they shut down the production of the plant because the management of the plant insisted on running the line so fast that people were beginning to become injured, to get injured. The hotel employees and restaurant employees, who I've been working with a whole lot, are in the process of organizing themselves to carry out a very important strike against 9 of the largest hotels in the city. They're building a strike support committee. I've got leaflets for people who are interested in participating in that. But those kinds of direct struggles in the plan are beginning to lead people to ask a broader range of questions. Like, what can I do to protect myself in the plant that I work in, to make sure that I don't get cancer or I don't, come down with something else, because I'm working with things that have a more long-term effect that I don't understand anything about or that I can't necessarily do anything about. I think that in that sense, there's a real alliance to be forged between environmentalists and workers. I mean, the Burma Resolution, look, she's a member of the Democratic Party. She's gonna, I think that there are many people in this room who understand that the Democrats and the Republicans for the last 20 years have led this country in such a way that the living standard of the lowest 80% of the population, that is workers, has declined to, in some places, a level at which it's very hard for people to just feed and clothe and provide for themselves. And I'm talking here about workers who are in industries like meatpacking, in industries like the hotel industry, but it's becoming increasingly true for workers throughout the metropolitan area. The Pepsi bottlers are out on strike, the Coca-Cola workers are in mediation. I mean, there's a lot of activity, and there's a lot of questioning, there's a lot of ferment, there's a lot of desire to know more, to learn more. I think that's one of the most important things that the group of people who are sitting in this room need to think about and need to work on is how do we forge those alliances between people who have access to the information and who have been discussing these questions for a very long time, and people who work in the plants. I'm not talking about officials, but I'm talking about people who actually work in the plants, who are actually handling this stuff, who are making products that, for all we know, end up in killing people in other places. I mean, we don't know what the long-term effects of all of this stuff is. But who are beginning to question, and who are beginning to reach out.
I think we all know some good contacts about the technical part, people who are working about toxics in the electronic industry in a very particular way. But I think you raised a broader question, which is how do we get more integration in our coalitions? How do we get more diversity? How do we get the pieces working together? And I think that's the kind of conscious action of the leaders. I mean, the folks in this room tonight are people who are leaders in various parts of this work. And I think you give a real articulate, passionate view about one of the bigger places where energy is coming. And I think if there was one aspect of the whole Seattle, I mean, Seattle was about the WTO in one way, but it was about a whole nother thing, which was the beginning of different kinds of people working together. We just need to, lift that up and keep it going here. And you described some of those specific struggles really well. Yeah.
As to your specific questions, I've got some numbers and names. Joe Ledoux is a medical expert on semiconductor hazards and the editor of the International Journal of Occupational Environmental Health. I'll give you his email address. Michael Wright is the industrial hygienist for your union in Pittsburgh. I've given you his phone number. And Ted Smith is the chief of the Silicon Valley Toxics Coalition. I have his phone number, and then you have my contact information on the other side of the car. I have to go to the airport. I'm sorry, I can't. Unless you want to give me a ride.
And we need somebody to give Barry a ride. Any volunteers? That would be great. Barry, thank you so much for flying out. Yes, sir.
This is a somewhat, maybe a little bit remotely related question, but we know that the aren't ever going to do anything about taxpayers having to pay through their tax money for the slush funds to clean up the pollution of the corporation. But are we ever going to do anything about health care? Obviously, these corporations are also causing a lot of health care problems. And the corporations are continually stopping, they don't want to pay for health care in any way, shape, or form. Certainly not through a single-payer plan and progressive income tax. Certainly not through increasing the benefits on the areas. I remember Rebecca Finch said once at a conference that they got 33-cent raise per hour, and 22 cents out of every 33 cents was a give back to the companies for increased health care. So, is anything going to ever happen with this so that these health care problems that do exist because of the corporation's pollution of our environment and the way that they have to work in their jobs, are they ever going to be made accountable? Once we get Ralph Nader elected, I don't think it will ever happen.
Well, I do think a big change is coming, and I don't think it's good, and that's that most of you know the WTO, the big round is stopped for the moment, but there are built-in components of negotiations that are underway. One of them is on the question of patenting life. The other big one is on agriculture, but the third one is on what they call services. And within services are things like water and teaching and healthcare. And so the WTO is going to be entering into negotiations which could bring, so to speak, trade liberalization to your local hospital, your local school, your local service provider of other kinds. And so
This doesn't stop them from causing problems.
no, it makes it worse.
Nobody's making them stop doing these things.
No.
Product liability laws domestically,
Oh,
to sue their pants off.
I've read Nader's book.
I just wanted to say a few things. If you want to learn more about harmonization, please pick up a harmonization handbook outside, and it talks about medical device harmonization, chemical classification harmonization, harmonization of the food industry, harmonization of cosmetics, harmonization of carcinogenic pesticide residues in food, the equivalence language in our new organics rule that you'll be interested in reading, and truck and auto harmonization as well as aviation harmonization. If you want to learn more about the WTO and its agreements and the binding dispute resolution system of the WTO and the cases to date, pick up one of our books. They'll be on sale outside for $15, or you can pick up a book order form if you don't have any bucks on you tonight. And in addition, I wanted to make one announcement. The Women's Cancer Resource Center is taking a precautionary approach to pesticides and is sponsoring a workshop on Wednesday, June 21st at 6:30 on how to have healthy lawns and gardens the non-toxic way. And they sponsored an earlier workshop of ours today, so I wanted to mention it. Let's take one more question and then we'll break for the day. Somebody who hasn't, have you asked a question?
Yeah, but I do so good a job. What's September 26th? What is September 26th, the meeting, the WTO meeting next?
September 26th. WTO meets every day, day in and day out. But you mean Prague, the IMF meeting in Prague?
What's the nature of that meeting?
It's their annual meeting, the ministers gather. I don't know.
Twice a year, one Europe, one in the US. There's not a particular agenda at this moment. There will be a sort of festivities.
Thank you all very
Just a short one. I can ask a good question too. It's about local, I'm wondering about, in the Minnesota, there are agencies in competition for particular definitions around manure management. You know, there's a generic environmental impact statement. The Department of Agriculture has one kind of interest in this. The PCA has been trumped by the Ag Commissioner, apparently, or something like this. I'm kind of wondering how, you know, we talked about how you presented how there's these large international issues. And we got the mayor, we got a local legislature, but what is an approach where we can bring these contradictions that are happening in our own governmental regulatory structure is not even hardly talked about or explained. I mean, how do you bring this to the fore somehow?
Public education, public education, public education. I mean, all we can do is write about it, talk about it, get it in the newspaper, get it in our, I mean.
Get it in the newspaper, that's a little bit.
I mean, to me, the fundamental thing is that we have to educate ourselves, and then at some point, turning that into organizing for what we want. I mean, most of the time, those actions that you described, those trumpings, are an indication of our power and of a success that we've had that somebody wants to overturn.
Oh, yeah.
And so most of the WTO things that are bad are in fact, yeah, their responses to a success that we've had. If we keep that in mind, it's not so disempowering. We're not always thinking, oh, this terrible WTO is killing us. In fact, we're winning, and they're trying to trump it and to turn it back. And it's like 35 years of consumer struggle and environmental struggle and whatever, you know, we've gotten a long ways. They're trying to roll it back. And that's how we have to think about it.
Yeah.
We're winning, and on that note, we'll end.